This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we speak about a trial court's failure to properly allow an insurer to take the examination under oath of parties it believes were involved in a staged accident, and why the statutory obligation to fight fraud includes the right to examine people claiming no-fault injuries under oath, and why an apparent staged accident requires the EUO to protect the insurer and the state against insurance fraud. The trial court initially denied Allstate Insurance Company's suit, stating that Allstate failed to show good cause and did not cite any contractual provision compelling the appellees to provide information in an examination under oath, an EUO. Allstate argued that it had a duty to investigate suspected insurance fraud and that the appellees had a contractual obligation to submit to examinations under oath. In Allstate Property and Casualty versus Gloria e Companioni, Isair H. Lubo-Rodriguez, and Mercedes H. Cervantes, the Court of Appeal of Kentucky on February 7, 2025, resolved the disputes. The Court of Appeals vacated the trial court's total denial of the petition, a lawsuit in Kentucky, and remanded the case for further proceedings. The appellate court found that the trial court overlooked contractual provisions allowing Allstate to conduct EUOs and binding precedent that permits inquiries into accident-related issues. The appellate court directed the trial court to reconsider whether good cause existed to allow questioning pertaining to medical treatment and solicitation following the principles set forth in a case entitled Deadweiler v. Grange Property and Casualty Insurance Company. The appellate court's decision emphasized the importance of allowing insurers to conduct thorough investigations, especially when they are concerned about potential fraud. The case highlighted the balance between protecting the claimant's rights and ensuring that insurers can fulfill their duty to investigate claims thoroughly. Gloria Companioni was driving a car insured by Allstate, which was in an accident with another car. Appellees Isair, Lubo-Rodriguez, and Mercedes Cervantes were allegedly riding in the car Companioni was driving when the accident happened. All three resided in Kentucky. 4 days after the accident, all three commenced care at Total Health Chiropractic and Rehab. The next day, 5 days after the accident, Appellees submitted personal injury protection, that is no fault, or PIP applications through counsel. The appellees requested reimbursement for medical treatment resulting from the accident and for any coverage available, including coverage for basic reparations benefits. Allstate filed a suit for an EUO pursuant to Kentucky statutes. The trial court was found to have erred in finding Allstate failed to cite a contractual provision which required the appellees to submit to EUOs. The trial court overlooked policy provisions relating to EUOs, but it also overlooked pertinent authority allowing inquiries into predominantly accident-related issues in EUOs. In sum, its total denial of the EUO petition according to the Court of Appeal, cannot stand and must be vacated, with the case remanded to the trial court for further proceedings. The appellate court directed the trial court to consider its guidance in considering anew whether good cause exists to permit questioning about matters of medical treatment and or solicitation via EUO, and if so, to establish any appropriate limits on such questioning. The trial court's total denial of the EUO petition was vacated by the Court of Appeal and remanded for the trial court to issue a new order allowing an EUO, at least regarding purely accident-related issues, and to reconsider whether good cause exists to permit inquiries pertaining to medical treatment and solicitation, and to provide direction to the parties as to the permissible scope of inquiry. In my opinion, Kentucky, like most states, requires insurers to maintain a special fraud investigation unit to help the state defeat insurance fraud and to protect every insurer doing business in the state from damages from fraud. Allstate, faced with an apparent staged accident, sought to examine the parties claiming injury under oath in its effort to fully investigate a potential insurance fraud. The trial court refused, but the Court of Appeals of Kentucky reversed, requiring the trial court to approve Allstate taking the EUOs of the three parties claiming injury. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. You can subscribe to the blog, and if you do, you'll receive notice of every blog posting, usually 5, sometimes 6 a week, and you'll gain access to more than 4,950 blog postings. You can also subscribe to the videos on YouTube and or rumble.com, and if you do, I'd appreciate it if you click on the like button on YouTube or the thumbs up button on rumble.com. Subscriptions to the videos and to the blog are free. And if you're interested in additional information about insurance, insurance claims, insurance law, and insurance fraud, please consider, for a very small fee, subscribing to my Substack publications. Thank you for your attention.